Thank you, Madam Deputy Speaker. I wish to speak to Amendment 42. Where a local authority provides land for public recreation, it can be held on a statutory trust that protects it. Parliament set out a process that must be followed if that trust is to be ended. It's not a brilliant process by any means, but at least it gives a central role to local authorities. In Danish Shropshire, the Supreme Court recently held that where those requirements are not followed, the trust quite reasonably remains in place. However, Amendment 42, first tabled by the Conservative peer Lord Banner in the other place, cuts across that to allow the Secretary of State to set aside those protections where the proper process has not been followed, even where the current local authority might not now support terminating the trust. It replaces localism with centralism. Lord Banner sought to justify his amendment on a number of questionable grounds, including the assertion that the Supreme Court decision is causing considerable uncertainty in relation to land purchased in good faith from local authorities. The only example I'm aware of is a controversial issue in my Wimbledon constituency. In that case, the ALTC bought the freehold to a portion of Wimbledon Park in 1993 at an appropriately reduced price, having expressly agreed both to never build on the land and to restore full rights of public recreation after the expiry of a pre-existing leasehold interest. There seems little doubt the primary motivation behind the tabling of Lord Banner's amendment relates to the Wimbledon Park controversy. Unfortunately, despite previous assurances to leave the law unchanged before a proper consultation, the government rode in behind the Banner amendment. It would, however, have still been defeated had the Tories joined with my Lib Dem colleagues in the no lobby. Sadly, despite many assurances to the people of Wimbledon, every Tory peer either abstained or voted for their Conservative colleague, Lord Banner's amendment. As we've heard, the Tories tabled an amendment now retabled by the Honourable Member for Ruislip, Northwood and Pinner, to require the Secretary of State to write a report, lay it before Parliament and consider it. It was simply a tick-box exercise that would do nothing to stop Lord Banner's amendment coming to force. A parliamentary sleight of hand to pretend to the people of Wimbledon that the Tories had not abandoned them. And the shallow minister has the cheek to ask me why the Lib Dems refused to join them in this deception. My constituents in Wimbledon expect the legal protections to land to be upheld in practice, not set aside by ministerial discretion and Tory cons. I laid a motion to disagree with the Banner amendment. Under the arcane procedures of this place, I understand my motion will not be voted on, whilst the Banner amendment will remain. That marks a sad day for Wimbledon specifically, public trusts of land generally, and the credibility of the Conservative Party all across Merton, where the overreach of the ALTC is an important local election issue.